2681 A, B, and C. Ms. Bennett has not appeared here today. The time is 9:47 a.m. She was cited to be here at 9 a.m. Be a benchmark issue for failure to appear. Simone Brown, State of Ohio versus Simone Brown, PSC 24-1807, A, B, and C. Mr. Brown, you've done a huge amount of community service since your last time you were here. You're down to $470 left. That's all you've got. So no more community service, you'll have it been knocked out.
Yep.
I'll set you back and go out a little further for you since you're doing so well. I'm going to set you back December 29th. That'll be a review at 9 a.m.
Yes, sir. Thank you.
Thank you. Jason Collier. So the State of Ohio versus Jason Collier, CRA 2222 or 222, CRB 22-271, CRB 22-275. Sir, if you're on Zoom, we're going to need you to mute yourself or stop talking. You're interrupting court. All right, Mr. Collier, you're down to $311 owed on one case. It looks like that's restitution. And your other case is, I believe, maybe concluded at this point. Yep, looks like you've paid off everything on your other case, so you're just down to a few $100 left on it.
I paid it all this morning.
Oh, okay.
Yep. I think it was $446.
Your Honor, I believe you paid online. It'll be,
Okay.
No, I paid in here.
I show a zero balance on the computer, Your Honor. I'm sorry that wasn't updated.
Okay, that's fine. Mr. Collier, are you treating anywhere currently?
What's that?
Are you treating anywhere currently out of
No.
this case?
No.
All right, well, your case here will be closed.
Thank you, sir.
That's completed. Thank you.
Have a good day.
You too. Joshua Garbison.
Yes, sir.
All right, State of Ohio versus Joshua Garbison, TRC 24-726 A and B. Mr. Garbison is present via Zoom. It looks like Mr. Garbison's done all his community service. He's paid his fines. Have you done your DIP school, Mr. Garbison?
I'm currently enrolled in a 50-hour program here in Missouri that's required for me to regain licensing here.
Okay.
I did reach out to I had to change the case managers. My last one was terminated. So I've been trying to work out with the new guy to get you guys updated information. Currently I'm meeting with him at least once a week and then attending group classes every Friday for all-day classes.
Okay. Well, I'll set you back then on December 29th at 9 a.m. You're making progress, which is what we want to see. So you're doing what you're doing.
I appreciate it.
All right. Thank you.
Thank you.
Leslie Hammond. All right, this is State of Ohio versus Leslie Hammond, CRB 24-777. Ms. Hammond, looks like you are down to $210 left. Looks like the last payment was made last month in September. Yeah, in September, early September. Do you have a payment today?
I do have payment today,
Okay, how much you paying?
60.
All right. I'm going to set you back, but I'm not going to go quite that far on your case. Let's go to December 1st.
Okay.
All right, I'll note your $60 payment. You're going to make a $60 payment, and we'll see you back December 1st.
Okay, thank you.
Thank you. Brandon Helton. Brandon Helton. The State of Ohio versus Brandon Helton, CRB 2318, TRD 213585, A and B, TRD 213053, A and B. Time is 9:52 a.m. Mr. Helton was cited to be here at 9 a.m. due to failure to appear benchmark issue.
Alvin Lewis II, Buddy Malone Jr., Charles Nance, Dylan Spence, Scott Taylor.
Alvin Lewis.
Yes, sir.
All right, this is the State of Ohio versus Alvin Lewis II, PSC 25-8, A, B, and C, CRB 25-3. Looks like the last payment I see made was at the end of August, and you've got your community service done, but you still have a $900 fund. You have a payment today?
Yes, sir, I
All
do.
right, how much you planning on paying?
40.
All right, I'll set you back for December 1st. There'll be a review at 9 a.m.
Yes, sir.
Buddy Malone Jr.
Thank you.
All right, this is State of Ohio versus Buddy Malone Jr., CRA 25-133, CRB 25-135. Looks like you're down to $75 on the payment. You paid $100 in September, and you still owe community service. You got 30 days.
I get the community service done, I just gotta get the paper, bring it in, and I'm paying 20 on my funds today.
All right, I'm gonna set you back December 1st for review at 9 a.m. I'll know you're gonna make a payment.
Thanks, Your Honor.
Thank you. Charles Nance, the State of Ohio versus Charles Nance, CRB 25-331, CRB 25-291, CRB 23-386, CRB 25-37, CRB 19-237, and CRB 18-134. Looks like you've done 16 hours community service since your last hearing on one case. And it looks like you owe $435 on another. You've just got a lot of cases open. You're down to $36 on one, on the oldest case, and then it can be closed out. Do you have a payment today?
Made $50 online,
Okay. and
and I've been working my fines out too for community service at Athalia.
I'm gonna set you back for December 29th for review at 9 a.m.
Thank you.
Thank you. Dylan Spence, State of Ohio versus Dylan Spence, PRC 24-2330, A and B. Well, you're down to 9 hours community service left, and that's all you owe in the case.
I can complete it next week.
Okay. All right, I'll set you back for December 1st for review at 9 a.m. If you have those hours completed and Mr. Cooper or Mr. Major clear you, then that will be canceled in case we close.
All right, thank you.
All right, thank you. Scott Taylor, so State of Ohio versus Scott Taylor, PRC 24-41. Taylor, are you still treating?
Huh?
Are you still in treating?
Yeah.
Treatment?
Yeah.
Okay. Do you have a report?
I have one, yeah. Sorry about that.
All right. Good report, Mr. Taylor. That's All you're down to is just completing your treatment. So I'll set you back for December 29th for review at 9 a.m.
All right, thank you.
Here.
State of Ohio recalls Kaylee Bennett. Mr. Smith has to recall.
Hi, Judge. I just got a text from Kaylee. The nurse is instructed to pick up her son. Apparently, he's at urgent care now. It looks like she sent pictures of foot and mouth disease or hand and mouth disease. But she was insistent she pick him up immediately, get him somewhere out of the school. She was on today's review docket. She will get some urgent care to provide to the court. She got this to me. I didn't hear she got called up, so there's a warrant issue. I'd asked the warrant be recalled and put on the next review hearing docket.
Your Honor, if I may, she was at community service yesterday.
Yeah.
Okay.
And it's not like her not to, I've got pictures if you want them, but you probably don't want to see them.
I trust you, Mr.
I didn't want to see
Smith.
it.
You're an officer of the court. So.
Yes, sir.
All right, I'll recall the warrant on that, and I'm going to set it for Monday.
I'll text her back and tell her this coming Monday. Thank you, Judge.
No problem. Thank you. October 27th, review 9 a.m.
We're ready for arraignment, Your Honor.
All right, the next group of cases we're going to call are all arraignments. So if you've got an arraignment, please come in the courtroom. And when you hear your name called, sir, you can have a seat. When you hear your name called, come down to the table on your right, my left, and I will inform you of the charge or charges against you, the maximum penalties involved, and then I'll be asking for a plea. You can either enter one of three pleas: guilty, not guilty, or no contest. When you enter a guilty plea, you're making a complete admission that you committed the offense charged. A no contest plea means you're not admitting that you committed the offense charged, but you're not contesting the facts surrounding that. And then if I think the state would have enough evidence, I can enter a guilty plea. You can also enter a not guilty plea, which means you are not admitting that you committed the offense charged. If you're unsure of what to do, you should enter a not guilty plea. It preserves all of your rights before the court. You have the following rights before the court. You have the right to remain silent. We're recording everything here today, and if you decide you want to tell me something about your case that may not be in your best interest, then it's being recorded, and the state of Ohio can then use that against you, possibly to convict you later at your trial. You have the right to have reasonable bail. You have the right to have an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at no cost after making sure that you qualify. And you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. If you would, call the first case.
State of Ohio versus Robert Stickler, case number TRC 25, 27, 22, A and B.
All right, this is State of Ohio versus Robert Stickler, TRC 25, 27, 22, A and B. Mr. Stickler, it's alleged that on or about October 18th, 2025 in Fayette Township, that you were operating a motor vehicle while under the influence of alcohol or drug abuse or a combination thereof, and that you had refused a test in the matter. That's an alleged violation of Ohio Revised Code Section 451119A1A. That is a first-degree misdemeanor. Maximum penalty on that is up to 180 days in jail, up to a $1,375 fine, a 3-year license suspension, and a 3-year license suspension. And it's alleged that it's a first offense at this point. Minimum penalty is 6 days in jail or 3 days in jail and 3 days at a driver intervention program based upon the refusal. A $575 fine and a 1-year license suspension. How do you wish to play?
Your Honor, on the refusing,
Well,
not guilty.
I'm going to go ahead and stop you there. This is on just the OBI portion of it. How do you wish to plead?
Not guilty.
Okay.
Yeah.
I'll accept your not guilty plea. You're also charged with failure to control in the same date, same township, and that is a minor misdemeanor.
Guilty on that because my tire
Well, I'm
running.
gonna take it as a not guilty plea across the board at this point.
Okay.
And that's a minor misdemeanor, the maximum penalty is $150 fine and court costs. Can you afford to hire an attorney?
No, sir.
All right, and my understanding is you already have another case with another attorney.
Yes, sir.
That's Mr. Steyer, so I'm gonna go ahead and appoint Mr. Steyer to represent you.
Uh-huh.
I'm gonna let you sign a $1,000 signature bond.
Uh-huh.
And I'm gonna set your next hearing for the same date as your other hearings.
Yeah, the hearing, okay.
Which is November 21st at 10 a.m. And that'll be a pretrial.
The
21st.
And all of your cases are set for that day at that time.
Okay.
So we're gonna
Thank you very
keep them all together.
You have a good day.
Sir. Were you fingerprinted on the other case?
You got my medication ready.
Where's you fingerprinted on the other case?
Okay. Well, you're
I
gonna
got my
have
American record that he wanted for that case.
Well,
You
we
want
can go back to your attorney.
Oh,
and come back up. You're gonna have to go down to the jail and get fingerprinted,
Okay.
okay? So you'll need to.
Do I get to go in the back?
No,
No,
I'll tell,
no, just.
sign right there.
Yeah,
Sorry, guy.
How much is the signature
I'm
bond?
here.
$1,000.
Wait on me in the lobby and I'll bring you a copy of this.
State of Ohio versus Jamie Welch. Case- Excuse me, Your Honor. Her attorney is not here yet, so
Okay.
we'll have to call it later.
We're gonna call this a little later in the docket. Your attorney hasn't arrived yet.
State of Ohio versus Earl Carter, case number TRC 25-1974, A and B. That's Mr. Roger Smith's case.
Okay. So the State of Ohio versus Earl Carter, PRC 25-1974, A and B. Let your attorney get in the courtroom here. All right, this is State of Ohio versus Earl Carter, Mr. Smith. It's an arraignment on failure to appear for a pretrial. You were already appointed on it. Mr. Carter, do you admit or deny that you failed to appear for your hearing? And I'll let you speak with Mr. Smith first about that.
Yeah, he had called the office, Judge, and he reached out to our office, and I had said him get in Monday or Friday. He showed up voluntarily, and that was about the time that it was communicated to the court. He already had a warrant, well, potential warrant, so we tried to head it off to have him showing up today.
Okay. Based upon that, I will call the warrant. Mr. Smith, when would you want to come back for a pretrial on this?
Okay. I'll meet you. We'll talk. You asked me when I'm, let me see, Judge. I have some November availability, not a lot, but I know I can find something. I could do the 17th or 24th.
24th would work better for.
Was that better for the court?
For the docket.
Okay.
All right, so I'll set you back for a pretrial, 10 a.m. on November 24th.
24th. You know, you should meet with him, write it down, and come in at that date and time. Thank you, Judge.
Thank you.
Thanks, sir.
Have a good day. Thank you, you too.
Your Honor, that's all the arrangements we do right now.
All right, so we'll move on to pretrials. All right, if you've got a pretrial, I need you in the courtroom, and I need the attorneys in the courtroom.
Pre-trial, we need to be in the courtroom now.
State of Ohio versus Ricky May, case number 25-185, A and B.
Can I grab my file, Your Honor?
You may. All right, this is State of Ohio versus Ricky May, COB 25-185, A and B. This is Mr. Waters' case, and we're setting a pre-trial. He stepped out to grab his file as he was coming in from the back of the courtroom.
Sorry, Your Honor.
No problem.
I think we've got a resolution, Judge, to these cases. For the court's information, if I may approach.
You may.
Mr. May has another case pending today, or pending that technically it was scheduled for the 3rd. I thought Judge Capper had set him off for today, but that one didn't make it on the docket. But the resolution that we have reached involves resolving all matters. And it's my understanding, and Mr. Hill can correct me if I'm wrong, it's my understanding that on the old cases, that the probation violation that has been filed in that case is going to be withdrawn, and that the terms of that probation would be amended to lift the restraining order that had been previously issued. And that relates to the old case. And then in that old case, Mr. May would continue on a term of probation for a period of 1 year from today. And then with the new case, it's my understanding that Mr. May would enter a no contest plea with the stipulation of facts sufficient for a guilty finding. And that in that case, the state would recommend a 10-day suspended jail sentence with a 1-year term of probation. And a condition of that probation would be that there would be no contact with the person involved in that new case. I've discussed all that with Mr. May. He's agreeable to that resolution. And if I recited it correctly, we can wrap up the whole thing today. He would have, coincidentally, 7 days jail credit at this point due to the old case.
Okay. All right, Mr. Hill?
All right, with respect to the case that's actually not set for today.
That's the 562, it looks like.
Yes. We are aware of the alleged victim's wishes in this, and we want to make sure that they're accounted for. And one of the things that she wants is a no contact order. So we are in agreement. If he were to plead, he could plead no contest, of course, and stipulate to the facts. And we would recommend a suspended jail sentence and a no contact order. On the previous case, which has a different victim, we are aware that she, on an earlier date, did not want a protection order. However, today is a different day. We're going to have to try to contact her. No?
She came here.
Did she say at that time that she didn't?
We told her no, because she never was several times in the past.
Okay. So she's already come before the court. This is Haley Corwin. She's come before the court and said she didn't want a protection order, so.
No contact.
A no contact order. So I guess under the circumstances, we will agree to that if the court finds that that's appropriate.
Okay. All right, so we'll start. With 25 case. Probation, and Mr. Galari, there's going to be a no contest plea with stipulation. Was that what I heard?
Yes.
Okay. So I'll accept that plea, enter a guilty finding, the probation, violation is going to be withdrawn on that case. And the probation is going to be amended for no contact order with Haley Corwin, and it's going to be 1 year probation from today's date.
And that no contact order is withdrawn and not part of his probation at this point with respect to Ms. Corwin, correct?
That's correct.
What was the period of probation, Your Honor?
1 year from today. That was what was indicated, unless you've got a different opinion on that.
Well, that was something that we hadn't spoken about. I would suggest that, I think that the normal procedure is 2 years, but I also understand that what we would propose is that if there's a period of time in which there's no further problems, that the probation period can be shortened in the future. But we've had so many different situations arise recently that I think that it's important that we maintain as much control over this as possible, make sure there aren't any further problems. It can't be terminated.
Well, the part of that comes from the judge and ask for it to be terminated. Usually what we do is there's no contact order. It's when the case is completed and I complete the case and take him off probation.
Yeah, Mr. Hill, I was unaware that that was not discussed, so I'll certainly listen to anything you guys have to say.
All right, so the issue then becomes, if there's a 2-year probation period and there's a no contact order, then that probation period is going to not be decreased, not be terminated early unless everybody comes before the court and asks for it, including the victim. The alternative is for the court to order a 1-year period of probation, but if there are problems, then the same thing can happen. We can come before the court and ask for the probation to be extended.
And Your Honor, just to respond to Mr. Hill's comment there, I've talked to Mr. May about that too. He would agree and consent to the term of probation being extended if there are further problems. He understands that. And so I think for purposes of placing all this on the record and for Mr. Hill's benefit, if there did continue to be further problems, Mr. May understands that the term of his probation could be, the state could move to extend it, and he would not contest that.
Okay. Well, why don't we do this? This may make sense, because I believe on this case, it was a plea on.
He's only got a few months left on this case anyway. How was it?
It was first set up for 2 years.
Right.
So,
Well, why don't we do this, because I believe that now that there's no further protection order out there, assuming the case will be completed, I believe that way you would have to come back before the court to complete the case.
if there's if the no contact order is dropped, yes, then I can complete it when he's finished with the case.
Okay, so we'll just leave the probation the same
Okay.
on this, and then assuming that if everything goes the way it would otherwise go, that'll take care of itself in a matter of course.
Understood. Thank you, Your Honor.
How long is it going to be probation with them?
On the first case, the one that dropped the protection. Now, the second one, is probation to last for the term of whatever the probation
Well,
is.
the second, the newest, we're doing a new
It is,
contact
yes,
order for
Yes,
that.
yes.
It looks like there is
Probation's for that.
a,
1 year on Emily Ellis. So,
there's already a review set for January 20th of 2026, so we'll just keep the same review date
Okay.
at 9 a.m. On the CRB 25-562, there's also a no contest plea with a stipulation to finding of guilt. Is that correct, Mr.?
Yes, that is
Walker?
correct, Your Honor.
Okay, I'll accept the no contest plea and a guilty finding on that. It'll be 10 days jail, all suspended. Give credit for the 7 that he did. Be a $100 fine and court costs. No contact order with Emily Ellis, 2 years probation.
Is it 2 years?
And I'll keep the same review date on that for the January review date, January 20th, 26th. That way, Mr. May, your cases aren't split up on different days, so you just have to show up on one day.
Yes, sir. And Judge, would you consider this is the case that's more problematic, I suppose. This is the case that we had discussed a 1-year term of probation. We actually had discussed shorter than that, but Mr. Major indicates that 1 year is about the minimum. This is the case, I think I was referencing earlier, that if there is a problem, Mr. May wouldn't contest his probation being extended, if that's okay with Mr. Hill.
Yeah, as long as it's made a part of the court's record that that's the case.
Okay, so I'll do the 1 year level 4 probation, and we'll make a note that it may be extended if there are further problems between the parties.
And then he's going to take care of the final court cost today, I believe.
Your Honor, if I may? He had an ankle monitor on in the first case. That will need to be, in order to remove that.
Okay. That's out of the CRB 25-185 case.
Thank you, ma'am.
Based upon that there is no longer protection order or ankle monitor to be removed and since the probation violation was also going withdrawn.
Thanks for your patience on this, Your Honor. Sorry it was a little confusing getting through the cases.
Thank you.
And then I guess I'll have Mr. May see Mr. Major before he leaves today.
Certainly needs to see Mr. Major for sure.
Understood. Okay, so don't leave. Go talk to John again, okay?
State of Ohio versus Madeline Wang. Case number TRC 25-2064, A and B.
All right, this is case number TRC 25-2064, A and B, State of Ohio versus Madeline Twain. This is Mr. Delauder's case for setting the pretrial.
Your Honor, this is one we discussed during the pretrial conference. It's my understanding the state's agreeable to amend the charge in this case to a violation of 4511-194, physical control, and Ms. Huang intends to enter a guilty plea to that charge.
Okay. And Mr. Hill, is that your intention is to make that amendment?
Yes, Your Honor.
Okay. We have discussed this during pretrial in the matter, and there was certainly some evidentiary problems that the state would face in this matter that would likely make a conviction to the ODI offense much less likely. So I'll approve that amendment. There'll be a $150 fine in court costs. Be 30 days jail, all suspended. Two years level 4 probation.
And Your Honor, on this one, Ms. Huang intends to pay her fine and court costs right now, today.
Well,
as you're aware, she's a resident of American Samoa and will be returning home.
Okay, yeah, she makes payment today, there'll be no probation.
Thank you, Your Honor. She'll do that right here after court.
All right, thank you. I need to set her a review hearing for, just in case it doesn't get paid,
Okay.
May 1st of 2026.
Okay.
Also a speed violation.
She has speed too, Your Honor.
Okay. Find her guilty finding on the speed. $100 fine, and no court costs.
All right, she'll take care of all that today before she leaves the court, Judge.
All right, review May 1st, 2026 at 9 a.m.
And she would not need to be here as long as she gets all this taken care of today before she leaves.
Correct. As soon as she gets it paid, the case will close.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Your Honor, I'm ready for some more arraignments.
Okay.
State of Ohio versus Charity Show, case number CRB 2568. Hey, Charity.
She has a disabled child judge that she was waiting for.
This is the State of Ohio versus Charity Show, CRB 25680. Ms. Show is present, and I presume with her attorney, Mr. DeWater.
Your Honor, we have received a copy of the complaint in this case. We waive the formal reading of the complaint, any defects in the time and manner of service, enter a not guilty plea for today's purposes.
All right, I'll continue the bond posted by Mr. Sowers. And Mr. DeWater, when would you like to come back?
If we could come back on November 10th, we may be able to get this resolved. And I don't think there's been any, this is filed as an M4 domestic. I don't think there's been any request for a protection order. I just want to confirm that because Ms. Show works at the same place her daughter works.
Well, I don't have any information on that yet. We're going to have to make contact with the alleged victim in order to make that determination. Otherwise, we'd be asking for a protection order. We understand there might be some extenuating circumstances here.
We'll tell you what, we'll recall this then here in a few minutes after the state has an opportunity to at least reach out. I don't want to issue the order if it's not, at this point, given the circumstances, if it's not requested. However, under abundance of caution, if they can't reach the victim, they'll have much choice.
Understood. And I don't think that Ms. Shook necessarily cares so much to have contact with her daughter while this is pending, so long as any order would not affect her work. They work at literally at the same place.
Where do they work?
Sanctuary.
At the sanctuary.
Nursing home.
It's a nursing home.
I work nights, I don't see her here.
All right. We'll make every effort to find out as soon as I can get somebody in here to help.
Thank you, Your Honor.
All right, thank you. Coming back November 10th at 10 a.m.
Okay. Thank you, Your Honor.
State of Ohio versus Darren Korn, case number CRB 2496A and B, and CRB 23761. Mr. Morgan.
All right, this is State of Ohio versus Darren Korn, CRB 2496A and B, CRB 23761. Mr. Morford's case, and we're set for, looks like an arraignment on a failure to appear. Mr. Morford, it's alleged that your client failed to appear.
I think these were just review hearings.
That's what I was, earlier today, it looks like.
Don't interrupt.
Or no, excuse me, it was on the 20th. There was a failure to appear for a review hearing on the 20th.
This month, Judge?
Yes. And Mr. Morford, did your client admit or deny that he failed to appear?
Did you vote?
I admit it.
Admit, Judge.
Did he have a good reason why he missed?
I honestly thought my fines were paid in full. It was miscommunication between my girlfriend and I because one fine was paid in full. I got my license reinstated and I guess I still have a couple hundred left.
Well, you got more than a couple hundred left, it looks like. In one case, you owe 250 on.
I have the paperwork, it's $275, Your Honor.
And then the other case is 275. So you've got two separate cases out there.
I'm sorry, I gave him printouts from both of those.
Yeah, one's at 0, one's at $275.
One
I think
is,
you may have read that wrong.
yeah, one is not at 0.
Okay.
Yeah, that must have been the wrong case from.
Is it total balance 0, total balance 275?
What's that case number, Mr. Morford?
Judge, it would be CRB 23-00076.
Well, that's the wrong case, Your
That's the
Honor.
one.
761 is his case number.
Yeah.
We were busy at the front desk, and I apologize, I must have.
I'm
Does
sorry.
that have his name on it or a different defendant?
What's the name on that case, Mr. Morford?
That's not my name?
Okay.
David Peterson, actually, Judge.
That'll explain a lot. So-
This one does say Darren Gordon.
Yeah,
The
so
clerk makes mistakes, Your Honor.
it happens. So, yeah, it was so the case number was CRB 23761, that is Mr. Cohen's case. And it's 258 on that, so there's a total of 525 owed
Okay.
between those. So we'll recall the warrant since you got in here quickly. And
Did get here in time, but actually hadn't been issued yet, Your Honor.
okay,
Did avoid the warrant.
one more fee. All right. We'll set you back for another review. November 7th.
That would be at 9 o'clock, Your Honor.
That will be at 9 o'clock.
Thank you.
All right, thank you. Thank you, Mr. Porter.
State of Ohio versus Jamie Welch, case number CRB 21-357, TRC 18-3432, A and B, TRC 14-1184, A and B.
This is statewide versus Jamie Welch, CRB 21-357, TRC 18-3432, A and B, TRC 14-1184, A and B, and TRC 14-1184, B. Just an old case. All right, we're set for, looks like an arraignment from back in February. And it's alleged that you missed a review hearing back on February 3rd of 2025. You admitted tonight that you failed to review.
I admit.
Okay, you have a reason that you
No,
missed?
sir. I've relapsed and I'm now staying at Safe Harbor and working a program there, and I just completed my phase 1 yesterday.
Okay. Do you have any type of paperwork on that?
Yeah.
Do you need to keep this, or is this?
Can I get a copy, please?
Just wanna keep
I
it?
also made a payment today.
Okay. All right, I'll recall the warrant since you went and got treatment. I'll set you back for December the 5th.
Thank you.
That'll be on the review docket at 9 a.m.
Thank you, Your Honor.
Thank you.
Ma'am, he'll bring you a copy out.
Okay, thank you.
State of Ohio versus Adam Raymer, case number TRC 22-327, A and B. Adam Reaver or Raymer?
The State of Ohio versus Adam Raymer, TRC 22-327, A and B. Mr. Raymer is now present in the courtroom at this time. Judge, that on or about December 23rd of 2022, you failed to appear for a review hearing. You admitted tonight that you failed to appear for your review hearing.
Yes, sir.
Okay. Do you have a reason that you failed to appear?
Yes, I do. I got life flighted to Grant Hospital. I was actually in there for about 10 to 13 days. I can't remember exactly. And then from that moment there, it just was chaos, you know what I mean? But yeah, so at that moment, that day of court, I did miss because I got life flighted. So.
I see you're in treatment now.
Yes.
When did you go into treatment?
I went to treatment, went to detox 3 weeks ago, and I've been at the counseling center since.
All right.
And prior to that, I had a ear clean.
Okay.
So.
I will call the warrant at this point. Has this case been? I'll recall the warrant. I'll put you back on the review docket, but I don't want to go too far out. So we're going to go to November 14th.
All right.
That'll be a review at 9 a.m. We'll see you back at that time, sir.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Jared Sipple, case number CRB 25-545, CRB 25-468, A and B. Jared Sipple.
Maybe recall this, Judge. He called my office, said he's on the way. He's supposed to have been here last week. I don't see him yet, but there's indications he's on the way.
Okay, we'll recall this a little bit.
Thank you, Judge.
State of Ohio versus Michael Anderson, case number CRB 25-613. Your Honor, this is a pre-trial.
All right, this is State of Ohio versus Michael Anderson, CRB 25-613. Mr. Smith's case set as a pre-trial.
Okay. Judge, he graduates Wednesday from OVP. Bree's not here, but there's a nurse here from...
Mackenzie.
I don't remember your name. Mackenzie is here from OVP. There's actually not a written progress report, but I'm told he does graduate on Wednesday.
So I'm assuming you want to come back?
I do, Judge.
I know your schedule's a little more hectic. You were available the 17th, is that correct, of November?
Judge, we set one for the 24th. You said the 17th was kind of ugly, the 24th.
Okay, 24th is
Yeah,
better.
we'll wait time, Judge. Let him complete his treatment, hopefully get the case resolved.
All right. You set back for pre-trial 10 a.m., November 24th. Give Mr. Anderson time to complete his treatment. I'll find that the council is waiving time on his behalf for that.
Yes, we will waive time.
All right.
Thanks, sir.
Thank you very much.
State of Ohio versus Jason Harrell, case number CRA 25-427, CRB 25-428, A and B, CRB 25-429, A, B, and C. Jason Harrell.
All right, this is State of Ohio versus Jason Harrell, CRA 25-427, CRB 25-428, A and B, CRB 25-429, A, B, and C. 9-7 pre-trial is on their hearing.
Seems to be doing well. I haven't heard anything. I haven't heard any negative remarks about him. A few times. He's persevered.
He's not falling through.
No, thank God.
Well, Mr. Harrell's not here, but it looks like he's
He's on
still in
teleconference,
treatment.
Your Honor.
Oh, he's on teleconference? Okay. Mr. Harrell's available via Zoom.
Looks like we're having technical difficulties.
He's muted, it looks like. Mr. Harrell, can you unmute your microphone?
Thank you, Mike. Good to hear you.
Maybe.
I think Mr. Major can't hear you.
All right. Well, it's Mr. Smith, where do you want to go from here?
Judge, looking at the report, it looks like he's doing well.
Correct.
I was wondering if he was available to speak with us, have us come back maybe in a month, use that 24th date if that's not too crowded.
All right, I'll set back for November 24th for pretrial and preliminary hearing. 10 a.m.
So our position on this is if we don't have the misdemeanor charges resolved next time, we'll just take what we can to the grand jury. Because he's got 4 theft charges and a possession charge. And we are being gracious with him to allow him to keep that felony case here and go to treatment. I'm glad he's doing well in treatment. This is more than just a shoplifting charge. Okay, so if he doesn't want to, if he wants trials on him or whatever, we'll take as much of it to the grand jury as we can and settle it in common pleas court, unless he wants to resolve them next time.
Judge, it's our hope that we will resolve this. I just haven't contacted him, he's in treatment, but I don't see that that's going to be the route we're going to take. I want him to get help. He wants to get help. I think we're heading the right way, so we will talk about that.
All right. Back November 24th?
Yes, sir.
10 a.m.
Thank you.
Thank you.
State of Ohio versus Brian Taylor, case number CRB 2112, CRB 23-112.
All right, State of Ohio versus Brian Taylor, CRB 2011, CRB 23-112.
You are.
Mr. Smith's case is set for a pretrial, looks like, with an excellent report.
Not to keep bugging you on that same day, but we could, that, or my next time is the 12th if the 24th is bad.
24th would be fine.
Okay.
All right.
We will.
10 a.m.
You're doing well. There's enough.
Thank you, Lenny.
State of Ohio versus Allie R. Martin, case number CRA 25474, CRB 25475.
This is State of Ohio versus Allie Martin, CRB 25474, CRB 25475. So Mr. Smith's case says preliminary hearing and pretrial.
I'm the leader.
Oh,
Yeah.
I have 30 days extension Wednesday. Basically.
All right. Good report.
she's anticipated to graduate the 4th of November, Judge, if we could do the 24th. It's a couple weeks after she graduates.
All right.
But she's doing well. She's pretty much a house mom up there, she tells me. So she's really doing everything, going above and beyond.
That's great news. The report's a fantastic report. We're proud of you. You're about to graduate, and then maybe we can get this thing wrapped up for you on the 24th. So I'm come back on November 24th for a pre-trial and preliminary hearing today.
It's going to be dismissed from
I've said that before, they drop out, they do something, and then I don't know what she told me. They're never gonna do this. You're welcome.
State of Ohio versus Jeremy McMillan, case number TRC 202410, A, B, and C. TRC 142341, A, B, and C. Jeremy McMillan.
I saw him a couple hours ago, Judge, but,
Jeremy McMillan.
okay, so I'm not seeing
Court
him.
case needs to be in the courtroom now.
You're right.
I think Jeremy's like an old view.
All right, this is State of Ohio versus Jeremy McMillan, PRC 202410, A, B, and C, PRC 142341, A, B, and C. Excuse me. All right, Mr. McMillan, good report.
Josh.
All right, Mr. Smith, same date you want to come back on?
We could, Judge.
November 23rd at 10 a.m. for the pre-trial. Mr. McMillan, good report. Keep up the good work.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Anna Schaefer, case number CRB 24549, A and B, CRA 23442, CRB 23443, A and B.
All right, this is State of Ohio versus Anna Schaefer, CRB 24549, A and B, CRA 23442, CRB 23443, A and B. Mr. Smith's case. So, well, this is one of the better reports I've seen in a long time. This is probably the most thorough report that I've ever seen from a treatment provider. So Orange County Recovery is setting the bar there. So excellent report.
Thank you, Your Honor.
You're welcome, Mr. Smith. November 24th again.
We could, Judge, we're getting a lot there, but these cases don't take a whole lot long, so everybody's doing what they're supposed to. I have no problem adding this one on the 24th as well.
It's a fairly light docket that day at this point. So,
Kind of Thanksgiving time-ish.
Yeah.
Yes.
What do we have, Your Honor, that's pending at this point?
looks like the entirety of the 549 A and B case is pending. And the 20. Looks like all cases are pending.
So we've got two different theft charges from one in 24 and one in 23, and we've got a possession charge. So these have been pending a long time. So I would suspect that if we don't have an indication next time about whether they want a plea or a trial on the theft charges, then we'll just have to set for a trial. And maybe we'll consider taking the felony case to the grand jury.
Well, that would be your prerogative, Mr. Field.
Judge, I just spoke with my client. That's what we anticipate doing next time. I just need to talk to her, but we're,
Sure.
yeah, we're not going to upset the apple cart.
All right, November 24th, for pre-trial preliminary, 10 a.m.
Okay.
Thank you, Your Honor.
We got to move down to the 5th, this Wednesday. Yes, I tried to do it with Zoom, but the judge wanted me there. I was dismissed to humor to report, but if you could tell.
State of Ohio versus Jared Stover, case number CRB 25501, and and CRB 24-461.
I'll get him.
All right, this is State of Ohio versus Jared Stover, CRB 25501, CRB 24461. Mr. Smith's case set for a pretrial.
OVC?
No, Valley Hill.
Get private insurance or?
Private insurance.
That's fine, okay.
Yeah.
Yeah. Okay.
Judge, he is at Valley, it's an insurance situation, so he's actually treated Valley Health, who we use, but not as much as the other providers. There's been an offer made this morning by Mr. Heald. I briefly discussed with my client. I would like to obviously go to the office, talk to it more thoroughly, if we could come back. Could we use December 12th? Is that terrible?
December 12th would be fine.
Okay.
The pretrial, 10 a.m., December 12th.
Thank you, Judge.
Thank you.
State of Ohio versus Amanda Piper, case number CRB 25447.
This is State of Ohio versus Amanda Hyden, CRB 25447. Smith's case, it was set for a trial, but I believe the parties have agreed to treat it as a pretrial play.
I think, well, I'm sure that there's a trial, so the state would have issued a subpoena. It was set for noon. I don't know if they were able to contact their client to get him here early. I did with Amanda, but you might want to recall. Is that right? You used to, I think.
Well, is Gary Arbaugh here? So he was subpoenaed for noon today.
Okay, we can recall it.
And if we could, Your Honor, if you could see in the file, your file, whether he was served.
Your Honor, there's a note on the computer docket that it was not served, 9/29/25, subpoena to Gary Arbaugh returned no longer at this address.
Okay. Did you hear that?
Yes. Well, we haven't had contact with him in several days, since September 19th. So I think we are left with the option only of nollying without prejudice.
All right. This matter will be sent nolly without prejudice, which means it can be refiled at another time. So presently, it will be dismissed unless until it's refiled.
Thank you, Judge.
All right, thank you.
Thank you.
Your Honor, we will ready to call some inmates from the jail. They're here back in Holy.
Okay.
State of Ohio versus Andrew Curry. From the Adams County Jail, case number CRA 23464, AD3, CRB 23463, CRB 2361, CRB 25506, CRB 23291, CRB 22351.
All right, this is State of Ohio versus Andrew Curry, CRA 23464, A, B, and C, CRA 23463, CRA 22361, CRA 25506, CRA 23291, CRA 22351. Mr. Stratton's case.
I only have one. Judge Collins has it.
approaching.
Mr. Hill. Get that yet? I've only read the first page, but I'll let you guys both take a look at this. Which cases it is.
Should they all should together? Yeah, there's two files. Should be, and this is one here. Illegal dumping, litter. That he's sort of thinking of as he's a victim of that property.
I'll be fine with that. What I would do then is, are you gonna waive reading of the violations? I will just keep the violations in our files, and then you guys can take the files and copies that you need. If that's the case, then there's a copy. Those will be your copies.
Your Honor, Mr. Curry, by the letter, kicked out of hometown. I just came from the patient department. Denial of those violations, and asked to be set next Friday for August 8th.
And ask if the council can have her talk to me for a minute.
I think so.
I won't get in trouble for going to school.
No. I need Adrian Curry's.
And this one, I need to recall the TPO dismiss.
I'll make the copies, Your Honor, if you need them. I'll make copies of it for him.
All right, we'll read it back. So what's the, bond or? Yeah, it's up to the judge.
All right, that's what I'll do then. I will set you a bond, sir. Be happy to set you a bond. It's going to be $100,000 cash assurity. You may not. We're all out of what you want to do right now. So we're going to set you back next Friday, 31st, at 10 a.m.
Are these all for future? One was set as a motion today. Was that a mistake or was there a motion on it?
We'll just reschedule it, accept our motion, and reschedule for the next meeting.
State of Ohio versus Randy Haynes, case number CRA 25679.
You may. All right, this is State of Ohio, this is Randy Haynes, CRA 25679. Now, this is set on a matter of expedition. It looks like Ms. Haynes, the Commonwealth of Kentucky, is asking that you be returned to Kentucky for, it looks like a flagrant non-support, and they're asking for a bond to be set in the amount of $30,000 cash in the matter. Now, you have the right to have an extradition hearing set in this. We can appoint you an attorney if you wish, if you can't afford one on this, but you have the right to have a hearing set, and we would reschedule that to allow the state to have an opportunity to present the evidence they need to do so. Now, if you wish, you can waive that right to have a hearing on it and say, I want to waive extradition, and I am the person, and I want to go back to Kentucky and get care. You have that right as well. If you wish to waive that, I would give the state of Kentucky probably a week to come get you. If they don't come get you within that week, we set it back on that day, and likely you'd be released if they don't come get you. Now, it won't resolve the warrant, and you could be picked up again on it, but you would be released at that time. Do you wish to be considered for court-appointed counsel?
I would like to wait, I want to wait it.
Okay.
But there's no way possible for to get a bond over here, and to where I can turn myself over there.
Well, I can set you a bond over here.
Cheaper?
Well, they've requested $30,000 cash without surety. I would be inclined to give you a surety bond over here, but it would still be, I would still do it at the $30,000 at that point. But it would be out of a lot of surety, so you don't have to post $30,000 cash. But if we do that, I'll set you the bond at $30,000 cash surety. And if it's not posted, Kentucky's going to have till October 31st to pick you up. And if they don't pick you up, you're going to be on the docket that morning here. And unless they have a good reason that they didn't come pick you up, you're likely to be released at that time. So I'm going to set you back. We'll have to have you sign a waiver form. I'm going to set you back on October 31st.
I'm giving them permission to give you back.
Correct, yes. Yeah. That way we can have it here or out here. All right, I'll find that Ms. Haynes has known to voluntarily execute a waiver of extradition in Kentucky. I'll give Kentucky till October 31st at 10 a.m. to come get you. We're also going to put on the docket here for October 31st to determine whether they did or did not come get you at that time. Okay? All right, thank you, Ms. Haynes.
State of Ohio versus Lisa Hammond, case number TRC 14-1590 A and B.
All right, this is State of Ohio versus Lisa Hammond, TRC 14-1590 A and B, CRB 14-465. Looks like, Ms. Hamlin, it's alleged that on or about June 16th of 2020, that you failed to appear for a review. You admitted tonight you failed to appear. Okay, you have a good reason why you About to appear. Okay, so you don't know. All right. I will accept your admission on that, but before I figure out what I'm gonna do with you, how many days have you been in jail? That's right. If I were to have your drug screen today, are you gonna be clean? Okay, well, have Miss Hammond's screen. Is there anybody like to screen Miss Hammond's? All right, Taylor's gonna come do a screen on you, and then we're gonna recall you a little later in the docket to figure out what we're gonna do. All right?
State of Ohio versus Jared Ray Meredith, case number CRA 25-543, CRB 2462, PRD 22-920, PRD 22-1036 A and B, CRB 22-263, PRC 20-2206, CRB 28-38 A and B.
This is Mr. Stratton's case.
He may be in the back.
Mr. Stratton. State of Ohio versus Jared Ray Meredith, CRA 25-543, CRA 2462, CRA 22-920, PRC 20-2206, CRA 28-38 A and B, CRA 19-756, CRA 19-780. This is Mr. Stratton's case, set for a pretrial and preliminary hearing.
Your Honor.
You may. Yeah. Point. There's a million things out there. I don't know. Which may not follow all of these. I do that one. 10,000 cash security. So, I'm assuming it's probably across. And there's air radiation treatment, RRS, on one of the cases. I would have him assassin to do what is required.
Your Honor,
We are set for a pre-trial and a pre-trial. I understand we'll reset the pre-trials and that they'll be allowed to move on all the pre-trials. As long as it gets an assessment, follows the recommendation. As for the felony, which is that there's 3 years, up to $50,000 fine, we're going to waive that. I understand the state's going to reduce that bond to $25,000 cash.
Is that correct, Mr. Mayor? All right. All cases, based upon the waiver with the requirement that Mr. Meredith be assessed. Looks like he was previously at RRS. Mr. Cantor, would you guys be willing to take him back if he cannot? Okay. Hometown can take you potentially. So there's going to be a requirement that you do an assessment, and whatever your assessment says you need is what you'll have to do to be bond out. So if it says outpatient, you do outpatient. If it says inpatient, you do inpatient. I'm sorry. Okay, well, I would anticipate, based upon the history here, that that's probably where things are headed, but I would imagine if you let them know that you want inpatient, they will certainly oblige you. Okay? But I'd like it to be that he gets assessed before he bonds out in case that it's an inpatient. So, yeah, I was going to say, if you want to assess him today, we'll know for sure. But I would anticipate, based upon him saying he wants inpatient, that it will come back as inpatient. So I find that he's knowingly and voluntarily waived his right to a preliminary hearing with advice of counsel. Amend bond on all cases to $2,500 cash or surety with
Your Honor, we ask that this on document next Friday to make sure he does bond out.
we can do that. I'll set pre-trials back on October 31st.
State of Ohio versus John Barker, case number CRB 14-1033. All right, well, we'll just set his... It's on the list they sent me.
We can get him on Zoom. I don't care to do it.
Your Honor, I'll contact the jail and have them try to put him on.
Take care.
I guess some regional, I'm not ready to do that yet, so I can get started.
That's fine. Just keep what's not going forward.
State of Ohio versus Joseph R. Doherty, case number CRB 25682.
All right, this is State of Ohio versus Joseph Doherty, CRB 25682. Mr. Doherty is present. Okay.
Joseph Doherty.
Yes, sir.
All right, Mr. Doherty, it's alleged that on or about October 21st, 2025, you did while voluntarily intoxicated in a public place in the presence of 2 or more persons, engage in conduct likely to be offensive or to cause inconvenience, annoyance, or alarm to persons of ordinary sensibilities, which conduct the offender, if the offender were not intoxicated, should know is likely to have that effect on others. That's an alleged violation of Ohio Revised Code Section 2917.11B1. That is disorderly conduct or misdemeanor in the 4th degree. Misdemeanors in the 4th degree carry a maximum penalty of up to 30 days in jail and up to a $250 fine. How do you wish to proceed?
Guilty.
All right, so you enter a guilty plea, you're making a complete admission that you committed the offense charge.
Yes, sir.
All right. I will accept your guilty plea as knowingly and voluntarily given, and I will enter a guilty finding. Mr. Heel, any input at this point?
I'm reviewing the affidavit, Your Honor. Your Honor, it sounds like alcohol played a big role in this situation, and that's concerning. Mr. Doherty is a young man, but this is the kind of situation that's way out of hand. So we would ask the court to order a suspended jail sentence that would be sufficient to motivate Mr. Doherty to attend to some alcohol counseling while he's on probation. And if he would do that successfully during his probation, then we would not want him to actually go to jail.
All right, be a $100 fine. I'll already pay the court costs. 10 days jail. I'll suspend them all on the condition that you go and get a drug and alcohol assessment, and you have to abide by any terms that they set to the assessment.
All right.
Be 1 year, or 2 years on before probation. I'm not going to do any community service on this. You're going to have a review date, May 1st, 2026 at 9 a.m. You're going to need to see probation to get signed up before you leave. And you'll need to speak with the treatment provider all along the back wall. I would suggest you go ahead and speak with one of them and see about getting the session set up.
All right.
Okay? right, we see probation before we go.
Yes, sir.
Thank you.
Thank you.
State of Ohio versus Charity Show, case number CRB 25680 on a recall.
Alright, this is State of Ohio versus Charity Show, CRB 25680. We were recalling this matter after giving the state an opportunity to reach out to the alleged victim about a possible.
Your Honor, it seems like for now the alleged victim is requesting a no contact order, which we're fine with, just so long as it doesn't interfere with my client's work. They both work at the same place.
And our alleged victim who wants the protection order understands that. I don't know what the employer is going to make of it, but as long as there's no problems, we'll be okay.
All right, I'll approve that. There'll be provision there that would allow her to work, but Mr. Valani, your client, wouldn't be able to have any contact with the alleged victim in that. And that is
Jaden.
Regis.
Jaden Regis.
Jaden Reyes. Jayden, last name Reyes, Reyes. We've already got a date of November 10th to come back.
Thank you, Your Honor.
Thank you.
State of Ohio resolved John Barker, case number CRB 141033.
This is State of Ohio, Ryan Barker, CRB 141033. Matter was set today for an arraignment on a failure to appear. Mr. Barker had a 10-day commitment to jail, which I have been informed was satisfied, so this case will be completed by the
State of Ohio versus Dalton Bradley, case number CRB 25681.
This is State of Ohio versus Dalton Bradley, CRB 25681. Mr. Bradley is present here this morning. All right, Mr. Bradley, it's alleged on or about October 22nd, 2025, you did, with purpose to deprive Walmart of any of property or services, knowingly obtain or exert control over said property or services, to wit miscellaneous merchandise, without the consent of the owner or person authorized to give consent. That's an alleged violation of Ohio Revised Code Section 291302A1. That's theft. It's a misdemeanor of the first degree. Misdemeanors of the first degree carry a maximum penalty of up to 180 days in jail, up to $1,000 fine. How do you wish to plead?
Guilty.
All right, I'll accept your guilty plea. And I'll enter guilty finding. If I have you assessed today, is there going to be anything to show up in your, or have you, if I have your instructions, is there going to be anything to show up today?
I don't believe so, no.
Okay.
I smoke
the legal version of marijuana, like the THCA, like they sell it like the vape store, that's all it is.
Okay. Well, we're going to recall your case, and I'm going to have you screened before I issue a sentence.
Okay,
Okay?
thank you.
All right. You would see Mr. McCann in the back, he's walking out of the courtroom right there. I'm going to recall this a little later in the docket.
State of Ohio versus Michael Calico, case number CRB 25602. Michael Calico.
She should be.
I'm here.
There she is.
All right, this is State of Ohio versus Michael Calico, CRB 25602. This is Mr. Stratton's case. It's said it's a pre-trial. Ms. Calico is on via Zoom today.
Yeah, she's in treatment, Your Honor. A little bit of a transportation issue there from the treatment facility. We just need to ask when she plans on completing. That way we can get her here at court and see if we can resolve this matter.
Ms. Calico, any idea when you're going to be finished with treatment?
It's actually a 1 to 2 year program. It's based on it's based on the person, like me, and how long I need recovery or whatever. But yeah, it just depends on me, honestly.
Okay. Well, Mr. Stratton, when do you want to come back? We're going to need to check in at least for a little bit.
Maybe give it about a month, Your Honor, and then maybe we can talk about how we can resolve it then.
All right, let's come back November 24th.
That's a bad day.
Bad day for you?
Yeah.
Sorry. Is there a better day for you, Mr. Stratton?
The 24th is bad, the 1st and the 8th are bad, so.
Of December?
Yes.
How about the 17th?
17th of November?
November.
Yes, that's fine.
Where is she in treatment? Where,
Ms. Calico, where are you in treatment?
I'm in Montgomery right now. It's called the Acre Project Homes.
Okay.
I'm in Montgomery, West Virginia right now.
All right, well, we'll see you back November 17th at 10 a.m. for pre-trial.
Yep.
You said November 17th, 10 a.m.?
Yes, ma'am.
Okay, all right. Thank you so much.
Thank you.
State of Ohio versus Tom Heisel, case number CRB 25608.
All right, this is State of Ohio versus John Heisel, CRB 25608. This is Mr. Stratton's case, set as a pre-trial. Note that the state was supposed to subpoena the victim in this matter.
is Tiffany Chapman here?
Yes, I'm right here.
You can come on out, man.
Oh, yes, you got to go. I had to take protection orders on him. Because he would not give me a vote. Another night. Yes.
Yes. Yeah, I just replaced it like last week.
She filed.
Yeah.
She said 90 days.
Yeah, the lady said it was a female judge.
No. Yes. I don't know how to do that. Yeah.
What is it?
Oh, sorry. Here, I need to see this. I need to see this. This is-
Your Honor, we'll set this for trial.
Like to set this for trial?
Yes.
Mr. Hill, start with you. When, would you want to, how long do you need to be ready for a trial?
Would you be able to be here about any time that we asked?
Yes.
We're going to have a trial.
Get down here and we'll talk to you. Okay.
So I would say sometime in the neighborhood of a month away, Your Honor, will be sufficient for us.
Well, we're getting out at the end of the, around Thanksgiving holiday at the end. I know you said, Mr. Stratton, the 1st and the 8th aren't good for you.
Correct.
What about the 12th?
The 20th?
12th.
12th? Yes, that's fine. December 12th?
December 12th. That'll be set for a trial at noon.
Come out and I'll wait and I'll talk to you in here. Okay.
December 12th, Your Honor.
December 12th.
State of Ohio versus Dylan Adair, number CRB 25609.
I thought I saw him.
I'm here, sir.
Right there he is.
State of Ohio versus Dylan Adair, CRB 25609, Mr. Dare's present on Zoom, and Mr. Stratton's case set for a trial.
So, Your Honor, this was, Mr. Adair was at Bellefonte, from Bellefonte to RRS, and RRS needed a higher level of care, so they sent him to White Light, Columbus. White Light Recovery in Columbus.
He was on a monitor earlier, I seen.
He's there, we just don't see him.
He's on monitor. So I presume you want to give him time to be able to
Yes,
work
yes.
on that. We'll keep that December 12th date.
Okay. Well, let's just confirm that with him there, make sure that he hears that.
Okay. All right, Mr. Adair, did you hear that?
What was it?
All right, so you're in treatment in Columbus, is that correct?
Yes.
All right, so we're going to continue this to allow you to get some of your more of your treatment done. December the 12th at 10 a.m. is going to be your next hearing. You're in Columbus.
Thank you very much. Can I say something?
Well, I would caution you maybe against it, but I can't stop you from saying something if you really want to. but-
Dylan, just as a...
I just wanted to say I didn't get in any trouble. They just recommended me to hire a cover so I can stay and be around other people.
No, we understand that, and we appreciate it, and we're glad that you're being treated.
No. Yeah, he wasn't in any trouble, we didn't. The court knew that, Dylan.
Yeah, we didn't think you got in any trouble, we just knew that you needed a little bit higher care, so. We'll see you back on December the 12th.
All right.
Thank you. December 12th.
Yep, 10 a.m.
You're sure.
Thank you. You have a good day.
You too, thank you.
State of Ohio recalls Dalton Bradley, case number CRB 25681.
All right, this is State of Ohio versus Dalton Bradley, CRB 25681. We had this matter recalled for a urine screen, and Mr. Bradley, you were honest on your assessment, and based upon that, I'll go ahead and sentence you after your previous guilty plea. It's going to be a $100 fine.
Okay.
I'll order you to pay the court costs. 10 days jail. I'll suspend all of them, so you don't have any jail.
No jail, okay.
You have 2 years level 4 probation,
Okay.
30 hours community service,
Okay.
and you'll have a review date of May 1st, 2026.
Okay.
That'll be at 9 a.m. You'll need to meet with probation before you go.
Okay.
Yep, you'll need to appear at the jail to get fingerprint order.
Okay, yeah, that's no
You're not
problem.
gonna be booked in
Right.
for any time. We've suspended all that time, but you still have to show up and get fingerprinted.
Yes, sir.
All right, you'll need to see probation before you go.
Okay,
All right, thank you.
thank you.
He was already fingerprinted.
Oh, he was, okay. All right.
State of Ohio versus Norman Branch, case number TRC 252106, A, B, and C.
This is State of Ohio versus Norman Branch, TRC 252106, A, B, and C. This is Mr. Morford's case, sentence to be trial.
What do you want to do with this? You want to submit it originally?
Yeah, I told her I put it on to do like the breakfast operation or something like that.
I wish I could help you.
They're not willing to come off that, is they? They're not willing to come off from OBI to a reckless.
That's my first offense.
That's your first offense.
Yeah, they were thinking that, like, said, well, even if
Judge, you mind recalling this? I don't want to take up too much of your time here.
Matter will be recalled later in the
I'll
docket.
talk to you in the hallway. Thank you, Judge.
State of Ohio versus Kevin Dale, case number CRD 24681.
All right, this is State of Ohio versus Kevin Dale, CRB 24681. This is Mr. Morford's case, set for pretrial.
How you doing?
Yeah, how about yourself?
Have there been any problems with marriage?
Nothing, ain't heard nothing from them.
Are you able to talk to the veterans?
Is Mary Ham here? Substance abuse counseling. Well,
It's
that's,
just doing their job. They got
okay, well, apparently it feels like he has that kind of a problem.
Do you have any kind of alcohol or drug problem? Would you agree to being assessed to establish that? Yes, Mr. Hill, he's willing to be assessed.
Okay.
He denies either problem. Judge, we're going to have this gentleman assessed for alcohol and substance use disorder. I'm not sure who would.
Mr. McCann in the back has raised his hand.
Okay. We've got. Recall it, Judge.
Recall the case.
Thank you, Your Honor.
State of Ohio versus Paul Lewis, case number TRC 252119, A, B, and C.
This is State of Ohio versus Paul Lewis, TRC 252119, A, B, and C. Mr. Morford's case.
How you doing?
I've set as a preliminary hearing for trial. It's an excellent report.
Stay the course, Judge?
When you want to come back, Mr. Morford?
Maybe a month or so, Judge. He's been at this about going on 2 months.
Are you available November 24th? If not, we're going to be out in December.
Yes, Judge, I'm free then.
All right, I'll set this matter back November 24th. Preliminary hearing and pretrial. At the defendant's request.
We'd waive time too, Judge, if that's the issue.
I'll find that time has been waived by the defendant's counsel on his behalf.
There you go. That's when we're coming back. People getting good reports.
State of Ohio versus Dustin Delaney, case number CRA 25-553 and 554.
The State of Ohio versus Dustin Delaney, CRA 25-553 and 554. Mr. Morford, set the preliminary hearing. Good report.
Same, stay the course, Judge.
All right.
Could we come back on the 24th?
That'd be fine. The defendant's request, this matter will be set back for November 24th for preliminary pre-trial 10 a.m.
State of Ohio versus Christopher Finley, case number PRD 25-1453 A and B.
Don't tell me.
State of Ohio versus Christopher Finley, PRD 25-1453 A and B. This is Mr. Morford. Yes, Mr. Morford, I apologize, I couldn't read it. So you said you were going to hire your attorney?
I didn't hire one.
Well, it's set as a pretrial today, and my understanding was you were attempting to get your license back.
Yes, sir, and I have a copy of my temporary. I'm just waiting for the real one to come in the mail.
Yes, you should. It's easier.
Oh, yes.
Secretary Fowler?
That's good.
It's my favorite. You just made me smile.
All right. I believe he's in a plea to this at this point. Mr. Heald, he's gotten his license back. There's a speed and a driving under suspension. He went ahead and preemptively gotten his license back. How would you prefer to handle this?
Well, I think under the circumstances, we're happy he's got his license back. So I think that maybe the speed is a different matter, that he needs to address that with the court, but we'd be okay with dismissing the driving under suspension if he were to plead to the speed.
You heard what the state of Ohio has proposed. Did you understand what he was proposing?
As far as I heard, they would drop the suspension and just do the speeding, correct?
Correct.
Okay,
And is that something that you'd be interested in doing?
yes.
All right, so on the speed offense, what plea do you wish to enter?
Guilty.
All right, I'll accept your guilty plea, enter a guilty finding. It'll be a $54 fine, however you pay the court costs, and the license is dismissed. You'll need to see the clerk before you go.
Okay, thank you, Your Honor.
All right, thank you.
State of Ohio versus Michelle Ava, case number CRA 2595, CRB 2594.
So the state of Ohio versus Michelle Ava, CRA 2595, CRB 2596. This is Mr. Smith's case, and we're set for a preliminary hearing. Excellent report. Looks like you're getting ready to transition over.
What was it? She's already in sober living now.
Okay. It's an excellent report.
Your Honor, if I may, I don't know if it reflects where she's going for the preliminary. She has done some community service.
Okay.
Yeah, and I just recently started working, so I haven't been coming to community service, but I think I'd completed it. I was just working to pay off the fines.
Okay.
Taylor.
It appears to be correct, Your Honor. Looks like she was given credit on September 25th. $50 towards the fines.
Okay. Mr. Hill?
Your Honor, if it pleases the court, it appears that Ms. Atha has done very well, and she's got a lot to be proud of on that. Previously, she pled guilty to the theft charge, which is kind of what started this whole thing, and she received a jail sentence, suspended, and I believe one of the terms was to finish her treatment successfully. She's gotten a long way on the treatment, and I've spoken with Taylor from Bethesda, who's supervising her case, and I think she agrees that this is, we're at the point where we could go ahead and dismiss the felony charge. She can continue to be on probation, continue working on her counseling, and I'm glad she got the job. And I'm being completely sincere when I say that I know my experience with Chick-fil-A is that they really hire good people. And so if she impressed them, then I think she's come a long way.
Thank you.
Absolutely.
No objection.
All right. The felony, the CRA 2595 will be nolly at state's request. And I'm going to set you a new review hearing on your case that you're on probation until it's finished up.
Okay.
You've done so well. That I'm going to go out into January. So I'm going to set you a review hearing on January 19th. That'll be a review at 9 a.m. You have everything completed at that point on the case, and probation tells you that you're clear, then you only hold it. How about January 12th then?
Yeah, she's just on probation.
All right, January 12th. So, once the probation clears you and says you got everything completed, then you don't have to do it here. Otherwise, we'll see you back on January the 12th, 9 a.m.
Okay, do I need to meet with a probation officer ever? Because
You don't necessarily need to meet with one today, but if you wish, you can. They will just be able to tell you what you got remaining to finish out.
Okay, so I just need to pay off the fines.
Or work them off on community service.
Okay,
Thank you, Your Honor.
thank you.
Good work to save up.
Thank you.
Isn't it amazing this is in every one of them? And that's not good.
State of Ohio versus Johnny Lee Maynard, case number CRA 25577.
All right, this is State of Ohio versus Johnny Lee Maynard, Sierra 25577.
You're interested?
This is Mr. Smith's case set as a preliminary hearing.
I try to get back to you on it.
Okay.
Because I want something myself. But I'm on the OVP first.
Judge, he's going to, it's OVP, he's been screened for QRT, he wants to consider that, and I think that'd be good for him if he wants to do it. If we could come back that 24th date or the 12th of December, either one.
Let's do December 12th.
December 12th.
The preliminary hearing.
We should do the OVP, we'll talk about it more then.
Yeah, I just want to know, like, does the court, like, want them, you know,
Yeah, I'll have David talk to you some more information at 10 o'clock. I'll have her reach out for the weekend, I'll see you that day. Right, Judge, I get here. Yes.
State of Ohio versus Michael Fritz, case number CRA 25469, A and B.
State of Ohio versus Michael Fritz, Sierra 25469, A and B. It's Mr. Smith's case.
Yes.
Set for a preliminary hearing.
They really will. Oh, great. So I have to read this. That's good. Good, so good.
Excellent report.
It is a very good report, Judge.
Presume you just want to continue the course?
I think so, Judge. He's got a job. He's gone from 3.5 to 2.1. He's doing what he's supposed to.
It is an excellent report. We'll come back to December 12th.
Yes, sir.
For preliminary 10 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you, Jared.
Thank you, Mr. Fritz.
State of Ohio versus Jonathan Gibson, case number CRA 2597, CRB 2598.
The State of Ohio versus Jonathan Gibson, CRA 2597, CRA 2598. Is also Mr. Smith's trial set as preliminary hearing. We've got a note that may be a completion at this time.
May I approach, Your Honor?
You may.
You guys good for that there? I guess that's all. That's what I got here. It's a big scene. Got this right there.
I don't read the next word. I don't read this word. So I have inside information from Bethesda that says that he's doing very well to the point that they think that he's reached the level of completion, which is great news. He did plead to the theft charge some time ago, but I believe the sentencing was delayed, so that would have to be done.
Okay. Any position on the felony?
We would move to nolly that this time.
Without objection, Your Honor.
We so nolly. And then on the CRB 2598.
Just confirm. Like call 259, calling 259.
Well, I'm apparently Siri has another plan today. All right. We'll do a $100 fine, or you pay the court costs, 10 days jail, I'll suspend all 10 of them, be 30 hours community service, 2 years level 4 probation, in order. Is this a Walmart case?
Yes, it is, Judge.
All right, we're going to stay on Walmart. And there'll be a review date for May 1st, 2026 at 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Thank you. All right. Sir, you'll need to see probation before you leave.
State of Ohio versus Alan Kennard, case number CRB 25686, TRC 252731, A and B. Your Honor, this is an arraignment.
All right, this is the State of Ohio versus Alan P. Kennard, CRB 25686, TRC 25731, A and B. All right, we'll start with the CRB case. Mr. Kennard, it's alleged that on or about October 10th, 2025, you did operate a vehicle, streetcar, trackless trolley within the state in violation of Provision A of Section 451119 of the revised code. When one or more children under 18 years of age are in a vehicle, streetcar, trackless trolley, while the defendant is considered to be under arrest for operating a motor vehicle under the influence of alcohol, drug abuse, or a combination of them, for operating a vehicle with prohibited concentration of alcohol, a controlled substance, or metabolite of a controlled substance in the whole blood, blood serum, or plasma, breath, or urine. That's an alleged violation of Ohio Revised Code Section 2919.22C1 of the Ohio Revised Code, endangering children. That's a misdemeanor of the first degree. Maximum penalty is up to 180 days in jail and up to a $1,000 fine. It's also alleged in case number TRC 252731 that on October 10th, 2025 within Proctorville Village, that you were operating a motor vehicle while speeding. That's an alleged violation of Ohio Village Ordinance 73.10B3. It's alleged 47 and a 35 miles per hour zone. That's a minor misdemeanor. Maximum penalty is up to $150 fine and court costs. And it's alleged in the B case that on October 10th, 2025 in Proctorville Village, that you were operating a motor vehicle while under the influence of alcohol, a drug of abuse, or a combination thereof, and that you refused a test. That's against Village Ordinance 73.01A. That is a first-degree misdemeanor. Maximum penalty on that is up to 180 days in jail, a $1,375 fine, and a 3-year license suspension. The minimum penalty on that is 3 days 3 days jail, or 3 days in DIP school, or 6 days jail, a $575 fine, and 1-year license suspension. How do you wish to plead?
Not guilty?
All right, accept your not guilty plea. Do you have money to hire an attorney?
Yes.
All right, you're going to hire your own attorney. How long do you think you need to do that?
I'm supposed to contact him next week for
I'll let you sign a
Appointment.
$1,000 signature bond. I'm gonna give you a little more time, because just contacting them next week, they may not be able to get you in that quick. So I'm gonna set you back for a free trial on November 24th at 10 a.m. If you hire an attorney, they may need to move that, they can do so, but if you haven't hired an attorney, or they haven't moved it, we'll need to see you back on that date and that time.
Okay.
You'll need to report to the jail for fingerprinting.
I'll bring you a copy of this out, Mr. Minton.
Okay,
All right.
sure.
All right, well, thank you very much, Mr. Bernard, we'll see you back on that date.
Okay. Thank you, Your Honor.
Thank you.
State of Ohio versus David Lamp, case number CRB 25683. David Lamp.
All right, this is State of Ohio versus David Lamp, CRB 25683. David Lamp. All right, Mr. Lamp has been called for today. It is now 11:59 a.m. All right, well, I don't have any real indication that Mr. Lamp was informed that he needed to be here this morning. This is from the village, so what I'm going to do is I'm going to lay this over to Monday. So I'm going to continue this for an arraignment on 10/27. And we'll see if he appears on Monday.
State of Ohio versus William Smith, case number CRB 25687.
State of Ohio versus William Smith, CRB 25687. Mr. Smith, will hand a copy of this charge. All right, this is State of Ohio versus William Smith, CRB 25687. Mr. Smith, it's alleged that on or about October 10th, 2025, you did knowingly use or possess with purpose to use drug paraphernalia, 2 lit, 1 glass smoking device. That's an alleged violation of Ohio Revised Code Section 2925.14.C1, possession of drug paraphernalia. That's a misdemeanor of the 4th degree. Misdemeanors of 4th degree carry a maximum penalty of up to 30 days in jail and up to a $250 fine. How do you wish to plead?
No.
All right, I'll accept your not guilty plea. You have money to hire an attorney.
No, sir.
Are you working currently?
Yes, sir. Probably.
All right, are you paid hourly? Are you paid hourly?
How do I what?
Are you working currently?
No, but I'm going for
Okay,
a job
sorry.
interview today at 2 o'clock.
All right, so I'll find that he qualifies for appointed counsel. I'll appoint Mr. Morford to represent you. I'll allow him to send $1,000 signature bond.
Need to sign your name right here for the bond.
Mr. Morford, when would you want to come back?
Judge, I'm pretty much at your convenience for the next 4 or 5 weeks.
Okay. Let's do November the 10th. That'll be a pretrial. And Mr. Smith will need to appear at at the Lawrence County Jail to get fingerprinted.
Did you hear that? You have to go to the jail to get fingerprinted.
It's still right outside.
Sir, I just got out of jail 2 weeks ago.
You still have to go get fingerprinted.
Okay.
So, we're not gonna, presumably, they're not taking you back in, you just gotta go get fingerprinted.
Yes,
So
sir.
if you wanna wait out in the lobby, they'll bring you a copy of your order. Okay?
Yes.
All right, thank you.
Love you. What?
Don't bring a piece of Get the phone number. Okay. You could go out and wait in the lobby.
Thank you, sir.
State of Ohio recalls Lisa Hammonds, case number TRC 14-1590, A and B, CRB 14-465. Lisa Hammonds.
All right, this is State of Ohio versus Lisa Hammonds, TRC 14-1590, A and B, CRB 14-465. We have Ms. Hammonds back out after admitting that she failed to appear for review. And have you seen a copy of your screen at this point? Yes. All right, so you know what you failed for. What I would like someone to do an assessment on Ms. Hammonds. All right, Taylor looks like he's going to come back and assess you, and we're going to have you out and see what you assess for some potential treatment. Okay? All right, so we'll have you back out here shortly.
State of Ohio versus Curtis Allen Hooser, case number CRB 25-685.
All right, this is Mr. Hooser's been handed a copy of his charge. It's the State of Ohio versus Curtis Hooser, CRB 25-685. Mr. Hooser is alleged on or about October 24th, 2025, in Union Township, you did knowingly cause or attempt to cause physical harm to Lane Packett. It's an alleged violation of Ohio Revised Code Section 290313A. Assault, that's a misdemeanor in the first degree. Misdemeanors in the first degree carry a maximum penalty of up to 180 days in jail and up to $1,000 fine. How do you wish to plead? All right, if you enter a guilty plea, you're making a plea.
I don't really know. I'm kind of confused here.
Well, let me work through this with you a little bit. I want to make sure you understand what you're doing. You can enter one of three pleas to this: guilty, not guilty, or no contest. If you enter a guilty plea, you are making a complete admission that you committed the offense charge. If you enter a no contest plea, you are not admitting that you committed the offense charge, but you're not contesting the facts surrounding that offense. And if I think the state has enough evidence, I can enter a guilty finding. So you're not admitting it, but you're not contesting it either. If you enter a not guilty plea, you are not admitting that you committed the offense charge. Now, if you're unsure of what to do, you should enter a not guilty plea because it protects all of your rights. Okay, I'll accept your not guilty plea. Do you have money to hire an attorney? Are you working? Are you paid hourly? How much do you pay? You pay an hour. How many hours a week do you get?
45.
Do you have any dependents?
2 children.
Okay. I'll find the qualifies. I'm going to appoint Mr. Smith to represent you. You're right on the edge of qualifying, but your dependents, I think, will put you over. So I'll appoint Attorney Roger Smith to represent you. Mr. Hill, do you want to be heard on the matter of bond?
Your Honor, we are preparing a protection order to keep Mr. Hooser away from Mr. Tackett. the alleged victim. We also have charges against Mr. Tackett today, but with a different victim. I'm assuming that all this happened in the same set of occurrences, so we want to make, first and foremost, sure that they're not going to be around each other. So our bond, I guess, our recommendation would be based on that, but I guess we probably would like to hear from Mr. Tackett also before we ask for any bonds in any of these cases.
All right. Well,
He's going to stay.
Yeah, that's, as far as I'm worried that this done, if they were.
So if that's the case, I mean, we're probably going to be okay with an OR bond as long as there's a protection order, but I still would like to hear from Mr. Tackett.
okay. Let's get Mr. Tackett out.
State of Ohio versus Lane Tackett, case number CRB 25684.
There's Sydney's here.
What's your name?
Spencer.
Sydney Spencer.
All right, Mr. Hill, if you want to, I don't know if you want me to go ahead and do Mr. Tackett's arraignment first and then fire up. And...
Yes, Your Honor, thank you.
All right, Mr. Tackett. And this is State of Ohio, this is Lane Tackett, CRB 25684A. And the 684A case, it's alleged that on or about October 23rd, 2025, in Fayette Township, you did by threat of force, knowingly caused Sydney Spencer, family or household member, to believe that said Lane Tackett would cause imminent physical harm to Sydney Spencer, family or household member. That's an alleged violation of Ohio Revised Code Section 29-25C. That is domestic violence, fourth-degree misdemeanor. The maximum penalty on that is up to 30 days in jail and up to a $250 fine. On the B case, it's alleged that on or about October 20th through the 25th, 2025, that you did in Union Township knowingly cause or attempt to cause physical harm to Sydney Spencer, family or household member. That's an alleged violation of Ohio Revised Code Section 2919.25A. Under Revised Code, that's domestic violence. That is a first-degree misdemeanor. Maximum penalty on that case is up to 180 days in jail and up to $1,000 fine. How do you wish to plead? All right, I'll accept your not guilty plea. Do you want to hire an attorney? Are you working at all? All right. I'll find that he qualifies. Mr. Stratton still here?
Should be.
All right, I'll appoint Attorney Sean Stratton to represent you. And Mr. Field on the matter of bond on this case as well. I know there's, you may want to inquire as to the matter of bond on Mr. Hooser first and then work our way back through.
I think that under the circumstances, OR bonds are acceptable. We are going to ask for Mr. Tackett to stay away from Ms. Spencer and Mr. Hooser to stay away from Mr. Tackett.
All right. I will allow each party to sign a $2,000 OR bond, and there's going to be a temporary protection order to stay away from the alleged victims in each one of the cases, which in Mr. Hooser's case is Mr. Tackett, and Mr. Tackett's case is Ms. Sydney Spencer. like to keep these on the same date if we can, even though I don't know that it really matters that much, but I figured for expediency for Mr. Hill with the victim, at least one of them, might make sense to keep them on the same day. I was going to say, I don't think we have a. Mr. Stratton, are you available the 24th of December? Okay, that's right. December 12th?
Yes.
Mr. Smith, you're available December 12th as well, correct?
Yes.
All right, I'll set both of these back on December 12th for pre-trial. Mercy sakes, they take that stuff seriously down there. For mercy sakes, they take that seriously down there.
Stable High versus Jerry Ray Merrill. CRA 25,543.
All right. This is State of Ohio versus Jared Ray Meredith. This is Mr. Stratton's case. And I believe he's assessed at hometown.
Yes, we're going to take him.
Okay. Mr. Hildy's bond was originally requested at $2,500 cash assured, and that was dealing with the felony. Are you still wanting a $2,500 cash assured bond to be released on treatment?
I'm sorry, it's not noisy.
It is really noisy. Do you want the bond to remain as $2,500 cash assurity, be released only to treatment because he waived to the grand jury on that, and that was the requested bond at that time? Or are you considering an OR bond and treatment as well?
Yeah, I guess we're good with our bond.
Okay. We'll need to do that as well in case he waives, or else it's going to be. Okay. So we'll make bond in all cases 2,500 OR, release to hometown for inpatient treatment. That'll be on all cases, including the felony that was waived. And any remaining cases that may be set years.
Oh, Jared Merritt, 10/31.
You already signed the waiver, Your Honor.
State of Ohio versus Anthony Merritt, Circuit Court, case number CRA 25,400, CRA 25,103, CRD 08-2201.
I'm getting closer. Oh, you can finish one.
All right, this is State of Ohio versus Anthony Merritt, CRA 25,400, CRA 25,103, and PRD 08-2201. Mr. Smith's case set as preliminary hearing and pre-trial.
Judge, I have a drug treatment done this one time for VP.
Clean
They're
screen.
supposed to drop that theft, remember, because they drove in case. She got all four doors back, I got all back.
Judge, we obviously want to get a report. We have an understanding if he successfully completes, there's a possible dismissal on the back end. Obviously, we're brand new in it, so if we can come back maybe that 24th or 12th day, whichever is better for the court.
December 12th.
December 12th, okay. So, okay.
Yeah.
Okay.
She's back here with me.
There you go. We'll see you then.
Thank you, Judge.
Thank you.
State of Ohio versus Alexis Niece. Case numbers CRA 25491, CRB 25365, CRA 25403, PRD 22766, PRD 21631, CRC 183327, CRC 191170, and PRD 1838.
All right, this is Mr. Smith's case as a retrial.
It is, Judge. She called my office, and I believe also called the clerk's office. She had another appointment that she unfortunately couldn't reschedule, and she's doing well. I would ask that if the court requires here immediately, that we come back maybe next Friday, because I'm confident she shows up normally, doesn't she?
Yes.
Yeah, and I'm not sure, that's why I can't give the court more information. There's some appointment that couldn't be rescheduled. I don't know. She is doing well. If you need her to come back next week, we can, or we can come back that 12th date.
Mr. Keel, any thoughts on that? It's a good report.
Yeah, she's compliant, so we're okay with that. I did discuss with Mr. Smith earlier today that she's got at least the theft charge from some time ago, back in June, that we need to address the next time.
I understand. We will. I'll speak with her. I don't think that's going to be a problem at all.
All right, we'll come back. Let's do December 12th.
Okay.
Since she's doing well. And
Yeah, she
got a
is.
good report and
Thank you.
the like. Doctor's a little crowded on the 31st anyway. And since she's done so well and has been since August, I don't care to go out a little bit further.
Appreciate that, Judge.
All right, thank you, Mr. Smith.
Thank you, Your Honor.
Thank you.
State of Ohio versus 6 Bentley, 6 Lee Sue Bentley, case number CRA 25359, CRB 25360. She is back in holding, Your Honor.
Why?
Or they told me she was.
Why are you back there?
All right, this is State of Ohio versus 6 Bentley, CRA 25359, CRB 25360. This is Mr. Smith's case. You may approach. And I believe Miss Bentley was taken into custody for a bond violation. And she was ordered to do treatment at TCC, and
She's
she's in drug court, so I think I should just check it, but I'm not sure what the revocations for. I've been 6 or 7 times. She says,
Well,
what happened.
she was ordered the treatment at PCC, and I'd like to hear a little about what happened there. What type of treatment was she doing while she was there? Not asking me, I'm asking treatment about it.
She came to us, she completed 2.5, went into 2.1. She was good up until the incident where she missed her appointment and lost her pass. She was told that she wasn't going to receive her pass when she walked out of one of her appointments, and then decided to leave ASA. What she's saying about being in drug court is true, though. We've had her there for a few months now.
Was she doing outpatient services with you or?
So it was outpatient, but it was partial hospitalization, which provides housing piece as well. So she was outpatient, but she was still in services with us residential.
Mr. Major, anything you'd like to?
I don't know much about it. I just got a message from Judge Capper saying that he found out that she tested positive, had family court in Soda County, and that she's left services, so a warrant was issued for her arrest.
Okay. Well, that may clear things up a little bit, Mr. Smith.
It does, Judge, because I was over with the problem.
She.
It wasn't a positive test, I was exposed to stuff. I passed my drug test, but you have to have a 50 to be negative, and I was at 51, so I was exposed when I left, but I was trying to get into another social living, and when I came back, I passed for drug court, and I passed for Mahajan, but when they did the send-off, it went over 1 point, so they had to count that as a, so I didn't use, but I was exposed to.
Well, Mr. Smith, I'll let you inquire of your client. I'd be real curious to know why she left what she was ordered to do.
I thought, I was under the impression that I only had to complete 2.5. I misunderstand.
Okay, well, that's a pretty big misunderstanding. Mr. Smith, any input from you, and then I'll ask Mr. Hill for any input as well. I think I know what I'm going to do, but I'm going to give the parties an opportunity to convince me otherwise.
Judge Office, I would like to see your treatment this instead of in county jail, which I know there's a price that you pay. You can't just leave and I get what she's saying about the drug screen being just over the tipping point, as it were. I would like to see her, back in treatment. She would like to go on some.
I'm actually doing drug where I'm going through, I have a job next week, like, still get our mind and
Mr. Hill, what's your thoughts?
Well, I was just reading the report from Counseling Center, and their recommendation is that she return to level of care in order to complete all goals and objectives of the treatment plan. So from our perspective, let's see, let me look at one thing here. We're okay with that happening. Now, she pled guilty to the theft charge previously, and she hasn't been sentenced on that. So the court still has quite a bit of leverage over her situation. And if the court were to go ahead and sentence her to the theft charge today, it might add another level of convincing to her situation. In other words, a large jail sentence hanging over her head might help keep her in line.
So, I guess one other question I would have would be, will PCC take her back?
Yes, Your Honor. we'd be willing to do that if that's what you chose to do.
So, Ms. Bentley, I'm going to give you a choice today, which I don't typically do. I can either go ahead and sentence you, and you're going to spend a whole bunch of time in the Lawrence County Jail, or you can agree to go back to TCC, but you don't get to pick where you're going to go. You're ordered to do treatment there. That was where you were ordered. You don't get to say, oh, I don't want to do it there. I would rather do it here. Or you know what? I can leave for a few days or 5 days or however long it was, and then I'll just check in somewhere else, and it'll just be okay. This is not up to you at this point. So I will give you those options, and I'll let you tell your attorney which one you would prefer.
Your Honor, is the felony still pending? I don't know that this is a resolution on the computer.
It is.
Yeah, the felony's still pending.
It is.
It should be.
It is.
Judge, she wants to go to TCC. Hopefully she's on her last case. Not going to be an issue.
All right, well, I would be inclined to keep your bond at 2,000 OR, but it being that you go back to TCC at the same level of care that you were at. Ms. Bentley, I want to see you do well. You're in drug court. I know that they want to see you do well. But we're at the point where you're past being able to say, I'm going to do what I want to do. And I'm glad that you're doing well overall. But even just you leaving and then going somewhere where you're exposed, as you said, and I'm not taking it for anything other than what you said at this point, but you going somewhere where you were exposed to drugs doesn't give me very good vibes on where your decision making is. And so, if you'd tested completely negative on everything, no exposure, nothing, that would give me a little bit better vibe as to where your head is and your decision making is. But the very fact that you even went somewhere around it at this point, with all of the progress you've made, is a little bit of a setback. So that's going to be the court's order. It's going to be released back to TCC with a $2,000 OR bond. All right, that'll be the court's order. When do you want to come back?
If you want to come back a little sooner, I think it's probably busy the 10th or 17th of November.
We'll probably squeeze one in here.
Or if not, actually,
Let's do the 10th.
I think we're going to.
All right, see you back on the 10th for preliminary and pre-trial.
Yes,
Your Honor, if I may, if she leaves with them in their custody from here, so she has all her stuff there, can TCC go to pick her up from there?
Yeah, I wouldn't have any issue with that.
Okay, thank you, Your Honor.
Yeah, being transferred between treatment providers, I don't have any issue with that.
Okay, thank you, Your Honor.
No problem, thank you.
State of Ohio versus Crystal Minton, case number CRA 25296, CRA 25297.
All right, this is the State of Ohio versus Crystal Minton, CRA 25296, CRA 25297. This is Mr. Stratton's case set for preliminary hearing.
Okay, that's right. Leave the name back. Okay.
Good report.
She has a good report. I think we are participating or attempting to participate in QRT. She's set to graduate. I don't think we're just quite ready to dismiss or anything yet. Just maybe a little bit to see how she adjusts to the environment.
Mr. Gill?
We are pleased with her progress on that, so whenever Bethesda's decided that she has completed their program, maybe we can move her over to QRT or whatever is recommended at that time.
Your Honor, it appears that if we could set it for some time in December, be the best.
December 12th,
Yes.
for a preliminary hearing.
Thank you, Your Honor.
Thank you.
No, I haven't really.
State of Ohio versus Michaela Mills, case number CRB 24657,
All right, this is State of Ohio versus Michaela Wells, CRB 24657. You may, it's Mr. Smith's case, assessed for assembly.
You got a script for some boxing or something, right? Okay. It's a shock. So,
Excellent report.
She's done very well. She's living back home. She has her kids back. So she's worked through a lot of stuff. She's working. Both her and her spouse are working. She's done really good.
Mr. Smith, Mr. Hill.
And I have a report from Children's Services that they have, the youngest child is there for a trial, which is significant progress. We're really happy. She's come a long way. So I think we need to make sure we follow it through and make sure that she gets all the way there. So we'd like to come back again.
Okay. December 12th?
Be fine, Judge, December 12th.
Be a sentencing hearing.
Thank you, Your Honor.
State of Ohio versus Kiefer Wilson, case number CRB 25416, A, B, and C, CRB 25416.
There's a bunch of errors.
This is State of Ohio versus Peter Wilson, CRB 25-116, A, B, and C, CRB 25-162. Set for pretrial special practice, May 14th.
How's work?
Taking her to kids' truck.
Okay.
Cleaners and that. Thanks for taking this.
Oh, you're welcome. I'll do that.
Awesome.
Well, Mr. Wilson, you've come a long way from where you were the first time I saw you.
Thank you, sir.
Yes.
Yeah, I do. Sure.
Continue on, Your Honor.
What do you need?
Is that one of our computers?
Yeah, it's one of ours.
Well, we're still having everything.
Remind me.
Your Honor, maybe next time, with the recommendation from his treatment team, maybe we could talk about maybe him looking at outpatient.
You here December 19th?
Yeah, I can do that.
We'll do December 19th.
Print it, but I
That'll be
can
at
type
7.
it.
December 19th.
I can't even want it in
Thank you.
Thank you, Mr. Stratton.
Thank you, Your Honor.
Good work, Mr. Wilson.
State of Ohio versus David Abrams, case number CRC 20-2197.
All right, this is State of Ohio versus David Abrams, PRC 20-2197, A, B, C, and D.
Your Honor, I'd like to apologize for standing up in court this morning. I just thought I was here for review. I didn't know that this happened.
Not a problem.
Okay.
One night action didn't hold it against you.
Yeah, that's,
All
yes.
right, it's a good report, Mr. Abrams.
Yes, sir.
It's not his.
All right, I'm gonna set you back for December 19th. I'll be a sentencing. Keep doing what you're doing.
Yes, sir. Well, what would be a good time to come in for the, because it's going to be this late every time? Is that,
Well, so it depends on the day. We set you at 10 o'clock, and sometimes you're in at 10, sometimes it's a little later.
is that a Friday?
That would be a Friday, yes.
Okay, yeah.
Would a Monday or a Friday be?
Friday.
Okay, December 19th then.
All right, thank you.
All right, thank you. Have a good day. You too.
State of Ohio recalls Lisa Hammonds, case number TRC 14-1590, and the CRB 465.
Well, we found that there was another issue. We haven't recessed. And there's another issue that was just brought to my attention.
She has a common placeholder for a probation violation, so I'm going to reach out to probation after we leave court and just see if they're willing to do an ankle monitor and release her. Can't make any guarantees at this point, but we would take her.
All right, so wait till she comes back out. All right, Ms. Hammonds. We've got a little complicating factor, but they're going to try to work through it. Are you willing to go into treatment? Okay. So you have a warrant on bond or out of a probation violation out of common police court. So I can set bond here. However, as long as they have a warrant out for you or holder, my bond effectively just sits there and waits until it can be done. So what I'm going to do is I'm going to set you a bond for 2,000 OR, release only to Bethesda for treatment. They're going to attempt to reach out to probation there to see if they can get you a bond set.
Okay.
If not, then you're held on their bond until such time as their bond changes. So but that's going to be our bond at this time here. I'm going to set you back for November 17th. And that's going to be a sentence.
We'll start working on it today. Thank you, Your Honor.
All right, thank you. Good luck, Ms. Hammonds. Thank you.
State of Ohio versus Kevin Dale, case number CRB 24681.
All right, this is State of Ohio versus Kevin Dale, CRB 24681, Commissioner Wolford's case. We're recalling this after Mr. Dale was assessed.
Yeah, I've got it set up for an outpatient assessment.
Okay.
It's already scheduled.
Well, gentlemen, where are we headed from here?
I'm sorry.
Where are we headed from here, gentlemen?
Recommend for outpatient?
Yeah. I assessed him for outpatient.
Well, then we'd like Mr. Dale to do that and be successful. And is Maryham here?
No.
So they're cousins. And she was real concerned about this being the outcome. And we're okay with looking at dismissing this charge later on if he's successful in completing his counseling.
Okay. Mr. Morford, are you available December the 8th?
Yes, I am, Your Honor.
All right, I'll set this back for December the 8th at 10 a.m. And Mr. Gale, you heard Mr. Heel, you are successful with your treatment, you complete your treatment on that, then they're looking at potentially dismissing the case against you. And you've got a strong incentive to do what you need to do. All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Moore.
State of Ohio versus Norman Branch, case number TRC 25-1106,
This is State of Ohio versus Norman Ranch, POC 25-2106, A, B, and C. Mr. Morphy's case, this was set in the pre-trial, wanted it recalled later in the docket.
We're going to have to change the plea, Your Honor.
Okay?
No contest with a record stipulation of facts for finding of guilty.
And that's to the
OBI.
the OBI charge and
Yes,
Mark
sir.
Lanes.
Yes, Your Honor.
All right, Mr. Branch, is that correct? All right. So I will accept your no contest plea and I'll order guilty finding. Mr. Guild, any special recommendation on sentencing, or is this just a...
Your Honor, it's a first offense. It's a relatively low score. We would ask for a suspended jail sentence and a 3-day driving program, a 6-month driver's license suspension dating back to August the 21st when this happened. And we wouldn't take any other positions on other sanctions.
Okay. We'll start with the A case. It'll be a $500 fine. I'll order to pay the court costs. 20 days jail. I'll suspend all 20 days. There'll be a driver's license suspension for 180 days going back to the date of the offense. 30 hours community service, 2 years level 4 probation. You'll have to go to the 3-day DIP school in lieu of jail, which is a driver intervention program.
Say that overnight?
I'm included.
Yes, sir.
3 days.
Did he need a permit for work?
Yes, Your Honor.
All right.
And to go to DIP.
Give him a permit for work, the DIP school, community service, and any medical appointments that he may have. And on the Mark Lane's violation, B case will be you can go ahead and nominate the B case. And on the C case, it'll just be a $20 fine. Mr. Range, on the see probation before you leave.
See probation before I leave?
See probation before you leave.
When do I have to do the 3 days school?
No. I'll talk to you about it.
All right.
Said you're going to set a review date,
Yeah, there will be a review date of May 1st of 2026.
May 1st?
May 1st.
That's when you come back, make sure you got everything done.
And then finish, so let's go ahead and see the probation.
See John May. Yes, sir. Thank you, Your Honor.
Thank you,
Mr.
John, thank you.
Thank you. Mr. Range.
State of Ohio recalls Jared Sickle, case number CRB 25-545, CRB 25-468, A and B.
Morning.
This is State of Ohio versus Jared Sippel, CRB 25-545, CRB 25-468, A and B, Mr. Smith's case.
Judge,
Single system.
That's not an issue. I mean, I'm not guilty. If you're not guilty, that's it for trial. Well, I'm not guilty.
Okay. We'll have to set a bench trial, Judge.
Okay. How far out do you want to go?
Well, I say that, this is really our first time here. Can we do one more pre-trial before the bench trial? Just,
Yeah, you can.
I think we might be headed towards a trial, but never say never.
December 8th?
I'm in trial that day, I know, without looking.
Oh, sorry. Okay, December 19th?
What was me not, so I just keep the dogs away and don't go around people with those
Yeah,
folks?
it's 30 days, and also spend all 30 days jail.
Oh, that's if I accept it?
Yeah, if you accept it.
Oh, no,
I got you.
not guilty.
19th, yes, Judge, of December. I'm here on a couple other cases anyway.
I appreciate the offer.
December 19th at 10 a.m., and that'll be one more pre-trial.
Thank you, Judge.
See you.
I should come in and talk to him. Sure. Perfect.
December 19th?
19th at 10, yes. Week before Christmas, 6 days.
Sorry to keep.
Hey, no, you're good, you're good.
I just don't know why they keep dragging it out.
I'll talk to you.
Thank you, Judge. Thank you. State of Ohio versus Glenn Gibson Jr., case number CRB 10-1078A and D, PRC case ABC, separate sentencing.
All right, this is State of Ohio versus Glenn Gibson Jr., CRB 10-1078A,
Your Honor, if I may, Mr. Gibson was here as ordered for community service. There should be an updated report.
Got it. Well, good news, Mr. Gibson, you're just down the community service lot, and still got a pretty substantial amount of hours, but you're making progress, so let's set you back on December 1st. We'll do a sentencing.
December 1st?
Yeah, 10 a.m. sentencing.
Thank you.
Thank you.
State of Ohio versus Brianna Morgan, case number CRB 22-01.
Your Honor, if I may, she was here as ordered also.
Okay. So State of Ohio versus Raymond Morgan, CRB 22801, present. Making progress, you're down to 18 hours left and $100 on the fine, so essentially 30 hours of community service will wipe your case out.
Gotcha. Is there any double Saturdays coming, do you know? Okay, I can still be here on Saturday.
All right.
Not a big deal.
Come back on yours as well, December 1st, and that'll be a sentence.
Is that 10 a.m., sir?
10 a.m.
Thank you so much.
It's like, I was wondering in my head who was going to be the last person to
It was
stand,
me.
so it's like it's you.
It was me.
So,
Thank you.
Thank you.
Have a good one. Thank you, George.
You too.
It was about 3 hours and here I go.
We are finished, Your Honor.
All right, court's adjourned.